of resources that exist to teach you these penalties. But once you've learned what these penalties are, what do you do with that knowledge? We know that under Padilla, silence, or the failure to advise a client of these risks, is per se ineffective assistance. But how can you use what you know to get better outcomes? So let's return to the 4 steps that we discussed before. First, investigate your client's individual facts. Then figure out your client's goals and wishes. Analyze the real-life impact of key defense decisions, and so advise the client. And finally, defend the case or negotiate according to your client's priorities. This investment will return measurable results in 4 major areas. First, improved criminal dispositions, risk management, better discovery, and improved life outcomes for clients. But let's take these briefly in turn. First, experience has taught that defenders can be successful at obtaining more favorable bail, plea, and sentencing results, or even outright dismissals when they're able to educate prosecutors and judges on the draconian consequences for clients and their families that result from incarceration and conviction. Prosecutors and judges respond best to consequences that offend their basic sense of fairness, those that are absurd, disproportionate, or affect innocent family members. Learn what the probable consequences are for your client using the categories that we outlined before. Focus on predictable penalties for specific clients and challenge prosecutors and judges to justify those consequences when they have the power to change them. If you know that a particular disposition will lead to the loss of permanent affordable housing, a stable job for a breadwinner, or deportation, ask whether prosecutors and judges are really serving the public safety by insisting on that disposition. Ask them to consider the unquestioned research that's shown that access to stable housing and employment are critical to reducing recidivism. Remind them that the Supreme Court has explicitly encouraged creative pleas, endorsing informed consideration of these enmeshed penalties by the defense, the prosecution, and courts during plea bargaining. But also remember that the defense bears the burden for a good reason. Sometimes the appropriate strategy is to avoid raising these issues. Second, knowledge of collateral consequences is a key risk management tool for defenders. Clients facing criminal charges will often have to face ancillary civil or administrative proceedings in housing court and family court or with employment licenses. Clients will often testify or give written statements as part of these ancillary proceedings. They are penalized for invoking the right to remain silent. And they'll testify about the underlying facts with or without their defense attorney. Defense attorneys have to be familiar with the collateral consequences so that they can anticipate these proceedings and properly advise clients of the impact of these proceedings on their criminal case. Now, proper risk management has another significant benefit, and that leads us to our 3rd category. As a result of being prepared for these ancillary proceedings, defense attorneys can use them for additional discovery not available in the criminal case. Eviction cases, employment licensing proceedings, DMV hearings, school suspension hearings. These are all venues where important witnesses might testify and where an administrative or lower court judge or even an attorney is likely to have subpoena power, allowing you to obtain documents otherwise unavailable to you. Finally, learning the consequences enmeshed with your client's criminal case and advising your clients of these consequences helps you build better relationships with your clients. It also empowers clients to choose outcomes based on their own priorities. The collateral damage of being arrested often falls most heavily on family members. When given the option, your clients will often choose the outcome that minimizes the impact on their families. So how can you learn these penalties? We have a duty to give clear, specific, individualized advice about these penalties. We have to learn the structure of these penalties in the same way that we'd parse out a complex new sentencing guidelines regime. The penalties may be complicated, but they're clear. And a support network exists to help you in this endeavor. First, the ABA is currently conducting a national jurisdiction-by-jurisdiction survey of adult collateral consequences that will prove invaluable. Next, ReentryNet is a national advocate support network and resource center on these enmeshed penalties and other barriers to reentry. It includes hundreds of resources offering practical strategies for mitigating or avoiding collateral consequences. On an institutional level, the DOJ Bureau of Justice Assistance has funded a national center for holistic defense at the Bronx Defenders. Holistic defense is an innovative, client-centered, and interdisciplinary model of public defense that addresses both the circumstances driving poor people into the criminal justice system, as well as the devastating consequences of criminal justice involvement, by offering criminal and related civil legal representation, social work support, and advocacy in the client community. The Center for Holistic Defense supports and promotes public defender offices, individual advocates, policymakers, and others who seek to redefine the practice of public defense in this way. You can visit the center at holisticdefense.org. Lastly, look to your local civil legal service provider as a partner in this work. You'll find that you largely work with the same client population. The criminal justice system is the institution with the single most pervasive impact on communities of poverty and of color, where interaction with the police and courts, as well as incarceration, has become commonplace. In fact, civil legal aid providers are the most likely advocates to have experience coping with the many collateral consequences that arise in areas of traditional poverty law. Visit lawhelp.org to find the provider in your area. At the end of the day, the court in Padilla simply outlined what every lawyer should be doing: deliver services that reflect reality. An attorney who ignores enmeshed penalties is not only not doing their job, they're actively doing harm. Think of a doctor who recommends that a patient take up smoking to promote weight loss. It's a short-term solution with disastrous long-term results. Yes, this approach requires more work and a more intelligent eye towards long-term strategy, but so does every form of good advocacy. Here's the fundamental truth. Incorporating knowledge of the broad range of enmeshed penalties into your daily defense work will make you a better lawyer. This concludes the defense portion of this video. I'd like to thank my colleagues Gwendolyn Washington and Benita Jen for their time in this program.
Good luck to you in incorporating crimmigration into your criminal defense practice in the future.
And remember, if you have any questions, we're just a call or click away.
Hi, I'm Scott Burns, Executive Director of the National District Attorneys Association. The National District Attorneys Association is the oldest and largest professional organization representing criminal prosecutors in the world. Its members come from the offices of district attorneys, state's attorneys, attorneys general, and county and city prosecutors with the responsibility of prosecuting criminal violations in every state and every territory of the United States. Our organization offers technical assistance, training, and research to prosecutors. I'll be sharing the prosecutor's perspective of the Padilla case. And although the Padilla case focuses on the Sixth Amendment requirement of criminal defense counsel to advise non-citizen clients of the immigration consequences of their guilty pleas, the case has many implications that affect prosecutors during the course of a case. This portion of the agenda will cover the prosecutor's role and an overview of the ABA model rules of professional conduct, the consideration of immigration status during plea negotiations, an overview of each stage of the case, including bond hearings, safe haven pleas, and sentencing, protecting the finality of the plea, and finally, Padilla's implications for victims. I would first like to talk to you about the prosecutor's role as a minister of justice. The prosecutor plays a dual role. First, representing the state, county, and community, and second, working to see that justice is done. The American Bar Association model rules of conduct are specific in following ways about how a prosecutor can help ensure that justice is done. You may also look to your jurisdiction for guidance. Rule 3.8 of the ABA model rules of professional conduct states, and I quote, "A prosecutor has the responsibility as a minister of justice and not simply that of an advocate. This responsibility carries with it specific obligations. To ensure that the defendant is accorded procedural justice, to seek justice for victims of crime, to pursue punishment and rehabilitation, to advocate for safer communities." Next, let's look at an overview of how Padilla may affect prosecution. We have compiled points for prosecutors to consider as a case goes through the court system. Padilla implications may affect all aspects of a criminal case. And as a prosecutor, you must know the implications of Padilla for possible plea negotiations and plea agreements in a case. Under Padilla, a non-citizen defendant can claim ineffective assistance of counsel. and can request setting aside, vacating, or withdrawing a guilty plea if he or she is not advised of the immigration consequences of pleading guilty to criminal charges. The non-citizen defendant must show that he or she was not advised of the immigration consequences of pleading guilty, and the lack of knowledge prejudiced his or her choice to plead guilty. How can the plea process be affected by Padilla? As you know, plea negotiation is a critical part of a criminal case. Recent statistics show that over 95% of criminal cases are disposed of by plea agreement. You must conduct, as a prosecutor, due diligence. Prosecutors must have knowledge of how the outcome of a criminal case will impact immigration status. Deportable offenses, prosecutors should be familiar with the categories of deportable criminal offenses. The categories are aggravated felonies. Examples include murder and violent crimes, crimes of moral turpitude, domestic violence offenses, drug offenses, and firearm offenses. As a prosecutor, should you consider immigration consequences when making a plea recommendation? Some district attorneys' offices have policies which prohibit prosecutors from even considering immigration status of defendants in plea recommendations. So check with your office regarding your policy. There may be potential issues with giving defendants what may be perceived as preferential treatment by considering their immigration status. Padilla does not require prosecutors to consider such consequences during plea negotiations, but it may be a consideration. Other practical applications of Padilla to prosecutors' cases, let's discuss bond hearings. The defendant may be a flight risk. Consider that the defendant may be more of a flight risk because of his immigration consequences, such as deportation, but always consider the defendant's criminal history and the nature of the offense when making a determination of a recommendation in the case considering immigration status. Next, let's discuss the type of pleas. Safe haven pleas. There are plea agreements that mitigate or lessen the adverse consequences. Defense lawyers may look for opportunities to avoid sentences or pleas that will have a triggering effect for immigration consequences. Some type of pleas that can lessen adverse immigration consequences include sentences under 1 year, sentences in days instead of months, or stacking counts consecutively so that no sentence is longer than 1 year probation. Probation over time and lesser included offenses. In every situation, you should always determine what is the appropriate plea in a case and maintain consistency. Next, let's talk about sanitizing the record. Make certain that the judge who takes the plea properly admonishes the defendant about possible immigration repercussions when the plea is taken. Carefully consider removing references to the offense that may result in immigration consequences and other charges which the defendant is not pleading guilty to. So how do you protect the finality of the plea? Well, there is no foolproof method. Here are some suggestions that prosecutors can use in order to protect the finality of the plea. Plea agreement paperwork. Make sure that the plea agreement paperwork that your office is using contains admonishments that include language that says that the plea may result in deportation, exclusion to this country, or other consequences. Make sure your plea is made on the record. This will ensure that there is a record of the plea, and the admonishments should be there if there is a later claim. Be sure to include a written admonishment in the plea agreement. We would suggest using language that tracks your state code of criminal procedure. Examples of such language could read as follows. The judge has told the defendant that he is not a U.S. citizen. This plea may result in deportation, exclusion from admission to this country, or denial of naturalization under federal law, and that counsel has explained those admonishments to the defendant. Make sure that there is verbal confirmation on the record that the defendant understands the admonishment and the plea. Victims. Prosecutors should approach any case with the victim of the crime in mind and be cognizant of the victim's desires. If there is a victim in the case, the prosecutor needs to speak to them and be clear about what is going on in the case and what may happen. The defendant may be deported because the criminal case is resolved. Victims should be prepared for all possible outcomes with the case. In conclusion, although Padilla focuses on Sixth Amendment requirements for criminal defense lawyers, there are many implications that may affect prosecutors, victims, and the outcome of the case. Prosecutors can use the National District Attorneys Association and the ABA as resources for information. Thank you.
Hello, my name is Darren Gales. I am a county court judge for the 11th Judicial Circuit of Florida.